Welcome to assignment number 10. Your motion for summary judgment was denied by the court, but before the matter is tried, a settlement is reached with all parties. Your assignment is to document the resolution of the litigation by drafting a settlement agreement. Half of you will draft a settlement from the plaintiff's perspective, and half of you will draft the settlement from the defendant's perspective. You're free to create the specific terms of the settlement, but try to be realistic. No million-dollar payouts. Since the vast majority of lawsuits are resolved through settlement, drafting a clear and precise agreement is an important and yet often neglected skill. Usually, the parties focus simply on the payment terms and leave any other settlement details to the lawyers. These details, however, are often important. Like retention agreements, there are dozens and dozens of form settlement agreements readily available. But not all settlements are the same, and careful, thoughtful drafting of a settlement agreement will help avoid future problems. Too many lawyers prepare a settlement agreement by simply cutting and pasting together various boilerplate provisions. This is a recipe for potential disaster. The last thing you or your client wants is to resolve the dispute and then months or years later end up in another dispute about what the agreement means or how it is applied. The primary purpose of this exercise is to make you think about what provisions should be included in the settlement agreement from your client's perspective. Mowat gives you some general drafting tips and provides several sample settlement agreements, but there are numerous additional provisions specifically relevant to the Peterson v. New York Times case that you should address in your settlement agreement. Be creative. No illustrative settlement agreements will be provided in advance of this assignment. You should come to your large section class prepared to brainstorm about potential provisions to include in your agreement.